Welcome back to the Constitutional Clarion. When most of Australia was focused on the US election, the High Court handed down its judgment in the YBFZ case. It held that the imposition of curfews and ankle bracelet monitoring on certain released immigration detainees was unconstitutional. In this video, I'll explain the reasoning of 4 of the judges of the High Court, and I will then do a companion video which explains the potential constitutional problems with the regulation that the government has given effect to substitute for the regulations that were held to be invalid. Now, for those of you who've been watching this channel for a while, you'll have seen that I did do a number of videos about the High Court's earlier NZYQ case. Now, this was the one that said that continuing to detain non-citizens indefinitely when there was no prospect of being able to deport them in the reasonably foreseeable future amounted to punishment and was unconstitutional because only a court, not the executive government, can impose punishment. I also did a couple of videos about the government's legislative response to NZYQ back in 2023. This included creating a new visa called the BVR visa for these released detainees. It permitted restrictions on their liberty, including curfews and ankle bracelets for ongoing monitoring of their movements. Initially, the bill, as introduced by the Albanese government, provided that the minister had a discretion to impose these restrictions on a case-by-case basis. The explanatory memorandum to the bill stated that the minister must act reasonably in exercising this discretion, taking into consideration the individual circumstances and the risk profile of the visa holder, as well as community safety and the rights and protection of others. The minister's second reading speech stressed that these conditions would not apply to all visa holders. The minister asserted that a rigorous assessment process would be undertaken to identify those individuals who pose a particular risk to the community and that these discretionary conditions will, quote, only be imposed where necessary for the protection of the community, unquote. Now, that was the position at 9:17 a.m. on the 16th of November 2023 when the bill was introduced. But it wasn't considered to be tough enough by the opposition, which pressured the government to impose such restrictions on all the released detainees. By 9:54 p.m. on the same day, the government capitulated and the bill was amended and passed with a compromise requirement that the minister must impose these curfew and electronic monitoring conditions, quote, unless the minister is satisfied that the holder does not pose a risk to the community, unquote. It was this provision that was challenged in the YBFZ case. Now, you might remember in one of my previous videos about it, I said that I thought that there would be judicial scepticism on the High Court of the alleged non-punitive purpose of such conditions because they apply regardless of whether the affected person has committed any crime, let alone a very serious one. They are imposed by the executive government rather than the court, and they apply in circumstances where the minister has very little discretion to render the conditions appropriate to the person's circumstances. Now, at the time, I gave any challenge to the law a fair chance of success. I pointed out that the conditions placed on the visa amounted to serious limitations on liberty that are commonly regarded as forms of punishment. I also noted that they were imposed by default unless the minister could reach that very high bar of satisfaction that the visa holder does not pose a risk to the community. I concluded by pointing out that the desire to appear tough was more likely to result in the laws being held to be unconstitutional and therefore ineffective, and that unconstitutional laws do not keep Australians safe. So, what did the High Court find in the YBFZ case? Well, pretty much what I said. It was a 5-2 decision with two justices, Justices Stewart and Beach-Jones, dissenting. Now, of the majority, 4 of them, Chief Justice Gageler and Justices Gordon, Gleeson and Jago, wrote a joint judgment. So that's the judgment that I'm going to explain here because it gives you a clear majority of 4. Their honours went back to the principles applied in the Lim case and the NZYQ case that detention will ordinarily be treated as punitive if it is imposed by the executive and will breach the separation of powers unless the law is, quote, reasonably capable of being seen to be necessary for a legitimate and non-punitive purpose, unquote. Non-citizens can be detained for the non-punitive purposes of deciding their refugee claims or, if their claim has been rejected, deporting them. But once there is no real prospect of achieving that purpose in the reasonably foreseeable future, the High Court held that it then defaults to being a punitive purpose and therefore unconstitutional. The most interesting part of the joint judgment in YBFZ is paragraph 12, where it starts expanding this principle concerning detention to a broader principle of the protection of human life, bodily integrity and liberty. It justifies the role of the court in this expansion by arguing that the doctrine of the separation of powers ensures not only protection from arbitrary punishment, but also the continuation of an independent, impartial judiciary to enforce lawful limits on the exercise of public power. In this regard, it would have actually been quite relevant to that HSC question that I discussed in my previous video. But of course, this judgment wasn't handed down until after that HSC exam. Now, anticipating the political flack that would most likely be attracted by its judgment in YBFZ, the joint judgment describes the judiciary as, quote, the bulwark of freedom, unquote. It also saw judicial protection of individual liberty against legislative or executive incursion as a deeply rooted core value. The joint judgment explained that every person has a unique dignity which the law respects and will protect. But, they cautioned, there is no free-standing constitutional right to protection from all interferences with bodily integrity or liberty. There are many interferences authorised by legislation which are non-punitive and therefore do not infringe on exclusively judicial power. If a law confers on the executive government a power that is prima facie punitive in nature, which interferes with the liberty or bodily integrity of a person, the majority said that one must ask whether the power is reasonably capable of being seen to be necessary in the sense of reasonably appropriate and adapted rather than essential or indispensable. So, necessary for a legitimate and non-punitive purpose. If so, it will be treated as non-punitive and not in breach of the separation of powers. Their honours considered that a curfew is prima facie punitive in nature. In this case, it confined the person's movements every night to a single location, and it had the effect of restricting how far the person could travel in the rest of their day. Some curfews, however, such as those for the purpose of preventing the spread of infectious diseases or to restore public order, are for legitimate purposes and therefore are not treated as punitive. The imposition of a monitoring device was also considered punitive by the majority. Its continued presence on the body was an interference with bodily integrity and it was also regarded as an involuntary restraint on the liberty of the person. It had to be charged for at least 90 minutes twice a day, and it was a criminal offence punishable by a mandatory year in prison if it was not recharged or kept in good working order. The case turned on the question whether these prima facie punitive restrictions could be regarded as for the non-punitive purpose of protecting the Australian community from future crime. The minister was required to impose these restrictions unless satisfied that it's not reasonably necessary to impose them for the protection of any part of the Australian community. So was that good enough to convert the purpose from being a punitive one to a non-punitive one? The joint judgment said no. The words protection of any part of the Australian community were too broad. They were not confined to protection from the risk of harm arising from future criminal acts. Their Honours pointed out that there was a separate regime in the criminal law which involved going to court to protect the Australian people from future offences, and there were also other visa conditions that applied where a person had been convicted of certain offences. The challenged conditions, in this case, could apply to released detainees who had never committed an offence. Their Honours also pointed to the many references in the parliamentary debate and the explanatory memorandum to the purpose of maintaining the confidence of the community in the migration system, which in more common parlance is keeping it off the front page of the Daily Telegraph. Not that the judges said that. The government, knowing that it was on very shaky ground, assuming they'd watched my YouTube video, had tried to bolster its position by using its non-statutory executive power to create a community protection board which advises the minister on the risks in relation to each one of these BVR visa holders. The joint judgment was dismissive of the relevance of this, noting that the board had no powers or functions conferred upon it by the legislation or regulations, and that it could not influence the proper constitutional characterisation of a statutory power. The participants in the joint judgment were unwilling to accept that all laws directed at protecting the community from harm of even criminal offending would fall within the category of laws for a legitimate non-punitive purpose. If that was so, absolutely anyone could be locked up because of the possibility that anyone might commit a crime in the future. The harm to which the laws are directed must be much more specific, and the law must be properly calibrated to achieve the purpose of preventing that harm. In this case, the law was not reasonably capable of being seen as necessary for the purpose of protecting the Australian community. It potentially applied to people who had never committed a criminal offence. It required the minister to apply the conditions unless he or she was satisfied of a negative, that it was not reasonably necessary to impose these conditions for the protection of any part of the Australian community. So if there were any doubt or uncertainty, or if there was even no evidence one way or the other, the conditions had to be applied. The conditions had to be imposed even when it had not been established that they were reasonably necessary for the achievement of the non-punitive purpose of protecting the community. They were therefore held invalid. Now, for those of you out there watching who are lawyers, and I know some of you do watch this, you'd know that the High Court now says that constitutionality needs to be assessed at the level of the legislative provision that confers the regulation-making power rather than the validity of the regulations themselves. Now, there was a bit of a fudge on this point in the judgment. It seems to have been accepted by all parties that the regulation-making power had to be read consistently with the Constitution as not permitting the making of regulations that would otherwise breach the Constitution. But the formulation of the questions in the special case did not readily accommodate such an answer. So the shorthand was used here that the relevant clauses of the migration regulations were invalid because they infringed on Chapter 3 of the Constitution, breaching the separation of powers. Well, what are the consequences of this? Well, these visa conditions are invalid in relation to all the released detainees who are on these BVR visas, not just YBFZ. The visa holders have reportedly been told that the curfew no longer applies and that they are no longer being monitored. They have to make an appointment to have the ankle bracelets removed by an authorised officer. The Commonwealth has made a new regulation which came into immediate effect on the day after the High Court's judgment. There was some confused messaging with the media that this somehow meant that the monitoring and the curfews would continue without a break. As far as I can see, that's wishful thinking on behalf of the Commonwealth and quite untrue, because there is an entirely new process that the Minister must go through under the new regulation to be satisfied of certain things before imposing such conditions again. What does that new regulation do, and is it valid? Well, I'll explain that in the next video. Thank you once again for watching the Constitutional Clarion, and as always, I look forward to seeing you again next time. Goodbye.